you could have a requirement, a density limitation of 4 per square. At however they may be arranged. The downside to that is you could all be on one block face, and that would be a huge impact on that block face. So the thing I think you're referring to is a process that doesn't exist that would be akin to a conditional use process, but it can't be a conditional use process because a conditional use process would result in a permanent entitlement. And we're talking about these types of permits being temporary uses. So I think there's nothing that is definitive yet in terms of a recommendation, what we've been talking about. And my guess is that between now and March 31st, when the council, when the deadline is evident, there's going to be a lot more conversation about this, and probably something, if the council latches onto this idea, a kind of definitive thing. So what we were thinking about, and I think we're just in the couple days since we've had our last meeting, we've talked extensively about it, and I think would be very comfortable with a recommendation that would be akin to the IZD appeal process, where an application would be submitted to the City Planning Commission staff. We would be reviewing it against whatever criteria are adopted for carving out an exception, making a recommendation to the council, and then the council would be granting an exception or not, it's similar to the way the IZD appeal process works. As far as criteria, the things that we've talked about are if it's a 1 per block face and that square has less than 4, then theoretically there's capacity in that square for additional, that maybe the exception is to limit the square to 4. That the exception to put more than 1 on a block face would then continue that cap at 4, but just in a different arrangement. I think if there's an unusual geographical circumstance that exists on a particular block, like it's really long, or if it's not developed and not hugely developed, or if it's there are a number of kind of edge circumstances where one side of the street is all commercial and one side of the street is residential, then that may be a circumstance that would make it less impactful to put a second on. Other ones that we've talked about, we've got a recommendation about the number of rooms that a short-term rental could have. So maybe the number of rooms, if it's 1 or 2 rooms, maybe that's more favorable than something that is proposing more than that. So really just having criteria in place that are clear, that we don't have today. I think in terms of your question about what you can do today as a commission,
right,
is maybe have, if that's something that you all would like to include in a motion or in a recommendation, to have endorse the idea of an exception policy based on specified criteria. If the Planning Commission staff council process is okay to you, then you can include that. If there's something different that you all think would be preferable, you could include that. But just to have as part of your motion, or have it as part of your recommendation, the endorsement of the idea of having some process that provides an exception, an objective way of evaluating exceptions to the block face restriction.
Good, thanks. Can I follow with?
I just have a clarification. You said that can you hear me?
Mhm.
Marty. Can you hear me now?
Speak into the microphone.
Can you
Very
hear me
close.
now? Hello, hello, hello. Can you hear me? Okay. So, just to be kind of backing up into your initial statement, because of the requirement of homestead exemption as a proof of ownership, you're going into this density and block face requirements. That's one of, like, is there any other way to prove ownership other than a homestead exemption?
So it's not an issue of how to prove ownership. It's an issue of limiting the impact. And so the homestead exemption requirement was put into place, one for a for it's kind of a safeguarding mechanism where if somebody were renting out their own home that they were living in, the presumption was that they would be much more diligent about policing the behavior that took place in that short-term rental. And so that was the kind of unifying thing that got a lot of people on board to the idea of having that be the threshold. And so without that there's a concern that that's missing. One of the outcomes of having the homestead exemption also was limiting the density in that there are there are a lot of homes and households here where that aren't subject to a homestead exemption. The people who own the property do not live there. It's rented out. And a lot of the short-term rental market is in certainly in the commercial world and in other places is whole home rentals, which from the very start was always seen as kind of the most detrimental version of the short-term rental. So having somebody on site and having that person be the owner occupant was always thing. So that in and of itself limited the density because there are not every home is like that. So
Yes,
that makes
so yes, absolutely. But I'm wondering if there's any way to limit, we have 3 different categories of SDR. And I feel like the category of SDR that people are most comfortable with are the very small 1-bedroom in your own house, 1 room or 2-bedroom, limited to 4 people. And more than that, and it's when you are the owner and operator living in the same house or lot or dwelling unit is when, you can make that is what the definition of that non-commercial SDR is. As soon as it becomes, you can own more than 1 property, and suddenly you're creating this as a business where you're buying multiple properties to create multiple operators, you are in the business of SDRs at that point, and it's a commercial use. So I'm just asking, is there a way to actually change the large SDRs into commercial use to where the smaller are still very small?
So let me 2 things. I think Laura handed out, and I think there's a slide. If you want to put the slide of the recommendations up. Again, since the meeting on Tuesday, we've, taking into account the comments you all had, the comments that were spoken at the meeting. I think one of the issues that came up was the size, the number of guest bedrooms and the number of guests. And so currently under the what is currently known as the small residential, there is 5 bedrooms and I'm not sure if is it 10 guests. So we would suggest, and we looked at the data to confirm that I think over 90% of the properties that were licensed as residential short-term rentals have 3 or fewer guest bedrooms. So I think an easy thing there would be to make the recommendation that no more than 3 bedrooms and 6 guests for what would now be called a non-commercial short-term rental. And then I think to your point about, and I think this was discussed a little bit before, we discussed the, there is going to be this bifurcation of ownership and operator, and they can be the same person. But because of the court decision, we can't require that the property owner be the on-site operator. And so a lot of the details of how that works out would end up in the city code in terms of the licensing requirements and the burden of proof to demonstrate ownership, and having a lease and an arrangement to show that whoever the operator was is the agent for the owner and is there with the permission of the owner. But with respect to the number that the owner had, I think we talked about the exact point that you made, was that having one property and having that property be managed as a short-term rental is one thing. Having multiple properties really changes the nature of that from more of a to more of a transactional, more of a business thing. I think the other layer to that is we are really talking about a situation where at the end of the day, we are more than likely to have more demand than licenses available. So we are going to be telling people, whether it's through a block face restriction, whether it's, however the density limitation happens, there are some people who are going to want to have licenses that are not going to be entitled to one. And so I think one of the lenses that we looked at all of our recommendations in the past couple of days is, if we're telling some people they can't have any, should we be allowing other people to have multiple opportunities to have different licenses? And so really just the equitable idea of, if we do have a limited amount, we should make sure that that as many people have an opportunity as possible.
When we spoke the other day about limited, I think we had landed at 5 or 6 per owner, but I still think that's a lot. I think if we limited that to 3, would make someone a little bit more comfortable that if you're a person living in New Orleans and you own 3 properties that you want to manage with responsible operators, that, I'm just trying to, again, like everybody else, trying to understand this from, living in a neighborhood where there are SDRs and listening to everybody else and the different problems. One of the other quick comments I want to make that nobody had kind of brought up is that there's no responsibility for guests who are actually coming and living and staying and enjoying these SDRs. When you travel in Europe or in other countries, you are required to give your ID, your passport, and pretty much they do a whole profile search on you, as to who you are. There's no accountability to the guests here other than the platform that they are on. So I wanted to ask safety and permits or the staff if there's been anything where there's guest accountability. Because yes, we can enforce as much as we want, but once the guests have some sort of accountability, maybe that's a way to also, deter some of the bad apples.
I have a question too. And the commissioner just touched on this a minute ago with the there seems to be less of a problem for as far as impact to neighbors when you have someone who is renting 1 or 2 bedrooms out of their home. They live there, i.e. residential zoning. And the residents who also have doubles who live on one side and rent out the other, also, i.e. residential. When you get into someone who owns a home, doesn't live there ever, and has an operator move in, as i.e. that sort of rings, that's why we're having trouble, I think, here, because that is the essence of a commercial enterprise, a boutique hotel. So I think that going at this with a temporary permit is the right way to go, and limiting it to where we're capturing those, as many of those that are lawfully doing this right now. The 90% that have these 3 or fewer, we're less likely to hit on people and say, no, we want that license back. You can't do this anymore. It sounds to me like those permits that are out there are the very thing that the commissioner mentioned, which is bedrooms in a home where the residence is present. Anything where the residence, the owner does not live on the property is going to be, in essence, a hotel.
So I think, the court and, we can certainly, the issue of the unconstitutionality of it is well, and let me finish, because I think it is related. The idea of a homestead, the purpose of a homestead exemption is to demonstrate that the person who is living there is the one who is the owner, right? And so what we're suggesting at this point is, because we can't require that the operator would not necessarily be, the operator would be a resident, would be living there as a full-time
Right, under
resident.
lease, which is this,
Under a lease.
under
yeah.
a lease. Okay. But they would have a lease. That would be their place where they live
Correct.
and enjoy the amenities of a residential neighborhood. And I think, but I do want to go back to the point that I think that the reason we're having so much trouble with this is because we're not approaching it through a zoning. And so I think we're going to be coming back to this. And I would prefer we take the zoning approach and look at neighborhoods and say, is it appropriate here? The neighbors say no, or the neighbors say yes. And until we do that, I think the tighter the restrictions are, the better, because then we're not clawing back licenses or,
And I just want to say that I think that it's not just policy. We can't force policy for bad actors or people who have whole home Airbnbs that needs to be enforced. And part of the reason that we're here is because it wasn't and has not traditionally been enforced. So if we have a city agency that's now dedicated to enforcement, and there are people hired to do that enforcement, and if there are people who rent an Airbnb, which because you have to provide your license to the site, and if there's a complaint by the neighbor to the enforcement agency and they come out, there is a possibility, and you can correct me if I'm wrong, that license would be revoked. Right? There's a policy in place and a procedure in place to combat those bad actors of constant parties and things like that. So I don't think we can make restrictions so tight that we're left with nothing, because it's frankly not fair. And there needs to be an ability for enforcement to actually do their job and enforce.
Can I ask staff one follow-up on the same lines that we're under what's before us, what you all have recommended? STR accessory partial is no longer a category. Is that right?
Right.
Okay.
B&B accessory is.
But in terms of STRs, you're making STR a non-commercial, and that's it.
Yes.
So there's no distinction whether it's one room, half of a double, or a whole house. Is that right?
Right.
I just
There
wanted
isn't a
to-
distinction. It's just the number of guest bedrooms and the number of guests, and whether the owner or the operator lives within the dwelling unit. They can live within the dwelling unit, within a room in the dwelling unit, or they can live on site, on lot in a different dwelling unit on the lot.
Would it be permissible to set up a different rule that applied to STRs that had only one bedroom? That wouldn't make any difference to whether their owners occupied or not. It would just be a different treatment of an STR that's small. Is that not, does that seem, I'm not asking for a total legal opinion, but we do have a lawyer here, and you all have been briefed by the city attorney. Is that a permissible distinction according to the number of rooms, regardless of whether it's owned out of state or in state?
So I think it would be absolutely permissible. I think the question is then, from a regulatory standpoint, is how is that treated differently? Is it and we went through a number of iterations when we were coming up with our recommendations. So for instance, you referenced there's this, the current partial versus the current small, right? Looking at the data, there are a number of properties where the same property had both. In other words, it was a double where somebody did a partial on the side that they lived on and then a small on the side that they didn't live on. Again, getting to the lens of we are at the end of the day going to be telling some people that they are not going to be having a license that they want to have. We felt that the equitable response to that was we should allow people to have access to one, but not multiple. So your question is would it be subject to the same density limitations? Would it be exempt from the density limitations? Would it be, those are all things that we absolutely discussed. And, I think all are legitimate. I think we felt that it as a starting off point. And again, there is always possibility, as the last few years have shown when we've been through this many, many times and amended things many, many times that, starting off simple and building on that to be more nuanced as we go forward is certainly something that we've always been thinking. And that was certainly a possibility.
So would it be possible? And I guess the question is, how would staff look on the idea of whatever the limit is per block or per block face or whatever? How would staff feel about an exemption from that requirement or one additional STR that has only one bedroom?
And so I think we looked at the different numbers of bedrooms and the impacts. I think that an STR is an STR is an STR. I think you're still having guests coming in and out. There's a real interest in reducing that kind of activity in the residential areas. And so, we thought a lot about keeping the existing distinctions, small, large, and partial unit, actually getting rid of large, keeping small and partial unit, keeping small to just one per block face, exempting partial unit, because that is the one that people are apparently feel has the least impact. But we ultimately decided that it was best, it's difficult to enforce that person is on site. So if you're saying people are renting out one guest bedroom and they're there while the guests are there, it's difficult for the STR administration to enforce that because it's hard. It can be difficult to prove that person is there in the unit. And so we felt as though while that type has seemingly the least impact, it's still an STR. It's still being used as an STR. You're still having guests coming in and out. You're still having cleaning services coming out, and it's still disruptive to the neighborhood. Typically that's the case. And that's why instead we thought that the best process is really this relief valve process that we've heard before. If there needs to be some kind of exemption, if the guest bedroom limit were smaller than the other STR on the block, if there were a number of reasons, there were no more than 4 on a square, that would probably be the best process for an additional STR.
IZD
appeal process
appeal
that,
process.
that Bob was discussing.
Right. No, that's what I was wondering out loud about, but what I'm hearing is that you all didn't want to put that, wouldn't want to put something like that in writing, but would rather leave it to the IZD appeal process. That could be one of the factors considered, but you don't want to make it a hard and fast rule of.
It's not whether we want to or not, it's just we haven't gotten there yet.
Okay.
So,
All right.
but that concept is certainly along the lines of what we were thinking, that if there were to be a relief valve, however that is administered and, you know, whatever criteria are developed, certainly one of those criteria could be that one more would be permissible, especially if it is of a type
Right.
that is
Less impactful.
Does this recommendation not satisfy that? The one that you have up on the,
It doesn't address that recommendation really
up to
would be the
max,
recommendation for those that are subject to the one per block base,
on per
Cap.
block, yeah.
that those would be limited to 3 bedrooms and 6 guests. And then I think what Commissioner Stieg was talking about is in addition to that, he was suggesting the possibility of having a possible second per block face, but only limited to 1 bedroom.
I would feel comfortable doing that if that 1 bedroom was owner occupied.
And again, we're
Owner
not
occupied, the
allowed
same
to
thing.
do the owner
Yeah,
occupied. Yeah.
I mean, owner occupied.
So also the reason that there isn't like a formal description of this relief valve IZD appeal process is because it's still sort of being crafted. I think it's a complicated thing. Providing like a waiver of a temporary use type is unique. I don't know what's been done before. And so it's still, the legal team is in consultation with safety and permits to really develop what that looks like. And that's why the opportunity is for you all to weigh in on what kind of restrictions you would like to hold that process to.
So I can share some of the thoughts that I've had the last couple of days or last 48 hours is just really limiting per block face. And is that 1 per square, which I didn't get any buy-in from on Tuesday. So a limit 1 per block face or 25% of the block face, applying for this temporary or something hardship similar to the tax or homestead exemption, not the homestead exemption, but the disability or age freeze. I mean, you could apply for a hardship. We also have that in variances as well, but that could be potentially the information. It's just, it's affordable housing, but it's the middle class. And we heard from so many individuals that this is how they're actually affording to live in their houses now. And so I think if we limit it and you don't meet that criteria, you could come here and apply for a hardship, and that could maybe meet, the 1 bedroom. But also, limiting to 6 people. I'm glad that you put this up here. But what about just limiting the amount of permits throughout the whole city? That's something that I've been really thinking about too. And I know we have a lot of bad actors in that. And Ms. Becknell had shared that we have 14 new and quality of life enforcement officers that have been onboarded this past a little bit, but we do. And I think that's been the biggest thing that the public also needs to hear, that the city is trying to make headway there. But can we also put a limitation on the amount of permits just in the city as well? 2,500 would be something so I want to hear from my other commissioners on that. Since none of you,
No, I'm for some sort of a limitation on permits, granted per year. A lot of cities all over the world and in the US do that. They grant permits for a 90-day period or just for the whole year, depending on, the city and their tourist load. So that is something to think about. And I would be, supportive of that.
how many legal permits are there? I know you mentioned it.
I think it's 1,223 residential permits. But let me just make sure I have the right number. And also that number was from January 6th. So we would have to find the number for today.
And we have these amendments to the preliminary staff report that we received. What is this information? Okay. Yeah. Got it. Thank you.
So it's 1,229. We've definitely seen other cities set caps.
Other cities do it in a lot of different ways. Some do it as a straight number, some do it as a straight percentage of the number of units, of dwelling units. Some do it as on a neighborhood by neighborhood. I mean, some limit it. And I mentioned this the other day that most, like the Savannahs and Austin and Charleston, limit it only to those tourist destination areas. And then within those have a percentage of the dwelling units in there that would be eligible to receive permits. I think one of the considerations that we've made and the reason why, you know, the block face limitation has an appeal is that it disperses the impact. You know, we've received lots of complaints, lots of comments about, you know, blocks where there are multiple short-term rentals and nobody lives there, and it's that's very detrimental to that really small area. Whereas some block with one may not have as much of a commercial presence, and the residential character of that neighborhood may not be as degraded as much. So a straight cap is certainly a density limitation, but it doesn't limit where they go per se. And so they could all end up in the same place.
But we're having such numerous discussions on block face. I'm not sure if everybody is on the same page about that. Every comment, email, everything is about block face. I'm not sure. Because the other question I had about block face is that if you have a residential neighborhood with a block face or block per block restriction, and you're abutting a commercial district or another mixed use district, that district has a whole different density in that district. So suddenly you have these two districts that are abutting each other. And what happens in that situation?
And could we just apply the appeal process? I mean, isn't that why we would put something like that in place to have a, what was it?
Yes, I'm
Temporary
questioning, I'm questioning the block face limitation.
With,
And the study that the staff has done.
I have a thought about with regard to residential abutting commercial. That is the situation they live in now. If you're in a residential neighborhood that abuts a commercial corridor, and we're in a diverse city where we're trying to encourage mixed use, then you already chose to live in a place where you're abutting and vibrant mixed residential commercial neighborhood. We don't need to start re-regulating that. We're here to talk about residential short-term
No,
rental.
we're not regulating that. I'm just questioning if you have block face limitations in a residential STRs in a residential neighborhood, but that residential neighborhood abuts a commercial, what is the situation?
I think it's the same as it is now. You're in a residential neighborhood and you're adjacent to a commercially zoned area.
I mean, I think the way we've thought about it is, you know, from the start of the whole short-term rental conversation, we've heard time and time again, short-term rentals are commercial uses and need to go in commercial areas. So I think we've always, as a staff, been less restrictive or viewed commercial areas as needing less restrictions around commercial short-term rentals, and that residential areas should be more restrictive. In those areas where you do have, you know, which, as Commissioner Lund says, it exists throughout the city. We have corridors that are adjacent to residential areas. We have spot zone corner stores and corner commercial spots where that are adjacent, that are in residential areas. So how do you deal with those adjacencies? I think one of the ways to do that is you look at the use tables and you look at the permissions and you look at the specific districts and you decide what types of uses are permissible in those different scenarios. So for instance, currently in the zoning ordinance, if you look at the neighborhood commercial districts, commercial short-term rentals are not permissible in all of those categories. You can only do the residential or the non-commercial type in certain areas. So the question then becomes, do you apply a block face if you're going to have a block face to those commercial properties as well? That is, you know, that's a question that's up for decision. I think one of the things we mentioned earlier also is that to the extent that those neighborhoods, there are a number of blocks throughout the city where one side of the block is zoned commercial and is developed as commercial, and the other side is zoned residential, but may have some lingering commercial or may have, some pockets of commercial. That may present a scenario where a straight imposition of a one per block face may not be as critical because the residential character of that block isn't as well established as other places in residential districts. So I think those are, the nuances that in a typical scenario would take lots of time and effort to dive into and that we haven't been afforded. But I do think the point is that this is going to be something that continues to evolve.
So you're saying that we will get to that point where we review the zoning of the resident, it is residential. And so we will take a district by district approach as we did with the master plan and the new comprehensive zoning ordinance to get those neighborhoods input into what they will accept as what kind of impact they want.
So what we've done is, and I think the use tables that are in our recommendations show how those use tables would change based on our recommendations. So all of the residential type come out of the use tables because we're no longer talking about permanent uses. And those live in Article 21, which is where temporary uses and the use standards that are associated with those, where those live, right? So those would be applicable, I believe, in all of the residential zoning categories. Correct me if I'm wrong.
It mirrors the existing short-term rental use permissions for residential small.
Okay.
So it's just the exact same districts that had been permitted, and where residential small is a conditional use, those are just prohibited as a temporary use.
Right. So we, in doing that, we erred on the side of being conservative. So if there were permissions there that were permissive of a permanent small or partial, that went to a temporary use. If it was a conditional use, that went to a prohibited use in the residential areas that we've done. And that's all in the staff report. I think what you're suggesting is there another kind of layer of analysis that looks at individual neighborhood by individual neighborhood. And that is not something that we have done.
No. I know that we haven't done it. I'm just saying that in the future, we're under a time pressure here. But when we get to this, I don't want us to be in a place where we've let too many temporary permits out there and people get, this idea that it will continue. If we're going to rethink this and say, yeah, the reason we're having so much trouble with this is because it's all about zoning.
So I think the beauty of the temporary solution is that it is not a permanent entitlement that can be revoked. And if the law changes and the city is no longer allowed to issue that temporary permit, there's no non-conforming use that accrues to the property and it simply cuts off.
So Madam Chair, so I'm going to make a motion to just put something on the table. And I'm totally open to friendly amendments. I want to say that up front. I'm not exactly sure which of the dockets this relates to. So can I state what the motion is and then you allocate it or tell me where to put it?
Yes.
So my motion is to accept staff recommendation with a limit of 6 guests per unit, to keep the 1 per block face, which is already in the staff report, to limit the number of units that can be owned by any natural person owner to 3, and to limit the number of bedrooms to 3, which is what you have on that slide up there. And the last component is to endorse the idea and ask staff to study the idea of how to establish a procedure that would, along the lines of what was just discussed, the IZD review procedure or appeal procedure, I don't know the technical term.
Yep.
To allow some consideration, some ability to have more than one per block face where circumstances warrant. That would be for future study.
Okay.
Thank you, Commissioner Steig. Is there a second before we open for discussion?
I'm sorry, Lori, what did you just ask?
I said we need a second in order to
Oh.
have discussion.
Well, first, before that, I would like to know if Commissioner Steig would consider the 3 per owner to 1. And I'm still not comfortable with the block face because we've heard that in certain neighborhoods, we've got more than if they're at capacity now, you could have a neighbor who has one next door and one directly behind. So, they're impacted. So I am still in favor of the 1 per block, but that did not really get any traction, but just that would be my amendment to your motion.
So, I want to at least put before, so I'm going to not accept the amendment about the owner because I wanted to put before us for consideration the idea of an owner. I'm trying to dissuade large scale corporate owning or large scale personal owning since it has to be a natural person. But I'm still sympathetic to the mom and pop person who rented out a side of her double and said, gee, that works, and has 1 or 2 extra units somewhere. And it's not a big gigantic business, but it's how somebody funds their retirement or pays the mortgage. We heard that. So I just want to keep the 3 idea in front of the commission, and if it gets voted down, great, but at least we consider it.
And Commissioner Steig, to confirm, is the idea for the methodology for an appeal, does that replace the lottery?
It would either replace or supplement the
Right.
lottery.
So this motion would not include the lottery.
No, the motion would include the lottery as the staff has put it, because temporarily I can't craft a whole procedure. And my appeal idea or review idea was definitely thinking of the blocks that people pitting neighbor against neighbor. I think that was a legitimate comment that people made last Tuesday, and that asking the staff to study some way to ameliorate that.
Great, thank you. Is there a second?
I have a question for Mr. Steig, Commissioner Steig. Is your thinking that if there is
Speak up, Commissioner Witry.
if there is an individual as a 4-plex and they live in 1 and they would get then 3 potential permits, and that would be to be 1 permit per unit. So would that be a 3-person because it would be on 1 actual property? Or are you thinking that they're living in 1 and then maybe across town they have another one? I'm confused.
No, that raises another loophole that maybe I should ask staff. So I was definitely thinking 3 separate properties, not, and wouldn't want 3 STRs in a single building, because then if we limit it to 5 people and you have 3 STRs in a building, now you have 15 people in the building, and that's what we're trying to get away from. At least I think that's what.
I thought the limit was 1.
Oh, is
Limit
it
is 1.
It's 1 per
license.
lot.
1 per lot.
Yeah,
That's what I
right
thought.
now you're allowed in certain cases, those 2 per lot or 3, depending on the
but under-
license type, but
under
it's
what's
1.
before
What's
us,
proposed is 1
Yeah,
per
so
lot.
it would go to the 3 properties, not the 3 apartments in the 4-plex.
Okay.
My problem with that is that You would have one person holding three and pushing someone else in the lottery for their one.
No, I hear that. I understand. I mean, that's what's so hard about this is balancing all these legitimate concerns. That's a totally legitimate concern. And I was thinking more of the person who's got a couple of units. And excluding that person if we limit it to one per owner, that's a legitimate concern. And that's what makes this so hard.
I guess Commissioner Steig, just thinking of it, and I'm thinking about what Commissioner Brown said earlier. I think just in the thought of it, it is one of those things that's very tedious as we kind of contemplate all this. And I think it's almost easier to kind of do the most restrictive as possible and let staff further review it and analyze it and open it back up, as opposed to just trying to, trying to figure it out right now, because there are going to always be those unique situations. And we want to do what's right for everyone. And particularly for residential neighborhoods. So I'm like, I share the same sentiments as Commissioner Brown when it comes to block faces and also ownership. So if we do get a second, unless that changes, I won't support it.
Good. I don't want to waste time. So, I mean, it's like I said, I'm open to front. Is two per owner better, or is it down to one?
Does anyone want to recommend another motion, or if Commissioner Steig would be willing to amend his motion?
To vote on that.
So I don't want to amend it down to one because that's not where my thinking is. I could amend it down to two. I'm concerned about the person who acquired a couple of units. I'll withdraw my motion.
Do we have any data on how many owners have multiple permits?
Yes, but I don't have it on me right now. Do you want me to see if I can get it for you all?
I just think that's an interesting stat, but we can continue with the discussion. Just, I don't
Maybe
know if that
Ashley has it.
Ms. Becknell has.
The residential, you don't have very many owners that have multiple, and if there are, it's kind of accidental. 'Cause people have-
Correct, because to date, residential has been required to have a homestead exemption, and you may only have one property with a homestead exemption. There has been a de facto limit of one.
If you have one property, sometimes you have the partial and the small, so you could have two, but
Or I know some
three and a large, yeah,
succeeded with the residential and then they went and bought in a commercial area or whatever.
yeah.
Commissioner Steig, was your motion, did it have a limit on the number of operator licenses a person could have? It has to be one, right? Because they have to live there.
I was suggesting,
They have to live there, right? So it can only be one
no,
For operators, yes.
for
owners, no.
operators, yeah.
for operators.
And I was suggesting 3 per owner and one, but keeping what staff has as 1 per operator.
Right. And so if you have to have somebody, if you own a property and you have to have somebody living in it who is your operator, it's just unlikely that there's going to be a proliferation. I feel like it's like you have an engine that's not operating in a car and you have this gunk all over it and you're trying to fix the engine, but you got to get the gunk off. And the gunk is all the illegal short-term rentals all over the city. And we're trying to fix the engine itself. That's not really broken. There's 1,100 or 1,200 residential short-term rentals in the city with 100. According to the data center, there's 192,000 homes approximately in New Orleans. So 1,200 residential short-term rentals is way less than 1%. And for other cities, when they put a cap, they usually use like 1%, which would be like 1,900 homes in New Orleans. And with the limitations that we have on with the homestead exemption, or if you replace that with something similar, like one operator, and even allowing an owner to have 3 homes. I think it's unlikely that many people are going to own 3 homes and be willing to pay 2 operators, you know, and make that their business and live in one. But so I think we're getting all focused on something that's taking a lot of our time and not addressing the problem. And I'm not offering a clear solution. I just don't want to go vote on all these super restrictive measures in a city where we need income for people, where people, for over 3 years, we've given people the right to have short-term rental income on their own property if they live there. And we're going to tell them that we're going to take that away. I don't want to vote on anything that's going to, without a solution for what to do with the people who have illegal short-term rental right now, you know, and we don't have a solution, then I feel like I would like to know legally where that would leave us if we cannot have a solution now for the people who have a license legally in their own home, then, and we're being told that their right is being taken away by the court decision, which I'm sorry, but I question that. I mean, could the court come in and say that all bar operators are no longer legal in a certain zone? I thought zoning law was allowed to be done by the parish, by the counties.
So
This is permitting. So I think that that's kind of where we get to the zoning being at the heart of this. But we're talking about, correct me if I'm wrong, we're talking about permitting here, not the zoning. I mean,
well, I think the issue that Commissioner Lund is raising about can a court declare something to be illegal? The short answer is yes, if the court finds that local government law is violative of the US Constitution. And that's what the court found in this case. So the city has not appealed that decision. And so the binding effect of that decision is such that we cannot have a regulatory regime in place with respect to short-term rentals that gives certain privileges to people with homeowners exemptions or homestead exemptions and not have those privileges be available to anyone else. And so
Then might we not be facing the same thing if we say, all right, now we're changing it from homestead exemption to 1 per owner or 3 per owner, and that an operator has to live on premises? Might not that also be challenged in court?
no, because I believe in the decision that the court wrote, that solution was included as a possibility, but it doesn't exclude non-Louisiana residents from the market. So if you are an owner and you live in Alabama, you can have a short-term rental license in New Orleans where a operator lives on the premises, and that would be constitutional. So that's where we are.
Okay. And could you explain to me again the time limit, why we have to take some action at this point?
Simple reason is the judge told us to. And the judge, the litigation that is pending is, the judge is hoping to get the city to settle. The judge is operating under the presumption that the continued operation of short-term rentals under the former regulatory regime is a continuation of the unconstitutional regime from the city's perspective. The extent to which the city allows that unconstitutional short-term rental regulatory regime to continue exposes the city to more and more damages because it's a continuation of a unconstitutional thing. So
Understand.
the March 31st deadline was to bring it to a conclusion so that those who were excluded in an unconstitutional way will have the same privileges as those who were benefited from that regime.
Right, okay, I understand, thank you. So for me, the priority would be at this point, establishing a way for the people who are legally permitted to continue to operate as a local body, you know. I'm not concerned about a proliferation of legal short-term rentals in this city. It's just not happening. The illegal ones are the ones that are proliferating. So I think our focus needs to be on maintaining, you know, a vibrant city. And I just think this will wreak havoc on the city to put all these people, you know, the people who do have the permits suddenly out in the cold. And I hate to pass a motion saying that we are directing staff to look into a way. I don't agree. The lottery system is not feasible to me with a business where people book make their bookings months in advance, you know, so you can't just suddenly stop and start the short-term rental business. I've seen in other cities, they have a lottery. Once they reach their cap for the city or neighborhood, then it's a lottery system for who gets a permit, but not for a year to year alternating who has the permit. It's not a feasible way to operate it. Ashley, is this because you have some input?
I do.
Thank you.
So the preliminary discussions on the way that lotteries would function would allow for people in good standing, holding permits that are in good standing, to continue to hold their permit year over year. The lotteries would be in the case of, after the initial set of lotteries, they would be in the case of folks who had moved and therefore had surrendered their permit, folks who had had their permit revoked. Or another situation in which a block that was previously occupied by an STR permit is no longer occupied. However, ultimately, that is a question for the council. The department at this point is just developing proposals for how it could be feasible, but we do think that that would be a feasible way to do it going forward.
Yeah,
Is-
and
okay.
just to be clear, our proposal is really like the amendments to the CZO, right? The comprehensive zoning ordinance, the land use, the administration of that permit, how the administration can provide those permits is up to them. And so we have been in conversation closely with Ashley and her team to understand what they're thinking and how it's going to roll. That's not actually something that we write in, like what system is administering those or how the system that they're going to use.
All right, I understand. We are a land use determination body.
Yeah.
Yes, but we ask for safety and permits to be here because I don't volunteer my time in order to just be here and do something that then falls into an abyss and doesn't work. Right. I'm going to look at the whole picture if I possibly can. So if it's within our, you know, rights to have safety and permits be here and tell us how the lottery works, then I'm going to do that. And I want to make sure I understand it. So the people who currently have a legal residential short-term rental license would be in a pool. And as long as they stay with an active license, they don't have to be concerned that they would lose it.
That's ultimately a question for our lawyers, our legal team, and for the council. My understanding is that as proposed by the City Planning Commission in their report, there would be a fresh start that would include an initial lottery, because any permitting right that was based on and premised on having a homestead exemption would be likely to be considered unconstitutional by courts.
And Commissioner Lund, this is where the pitting neighbor against neighbor comment came up, because there's nothing currently in the proposed docket that accommodated a process of appeal or some sort of temporary permit
Right.
to accommodate that.
Can we consider putting something like that in our motion?
So that was part of Commissioner Steig's initial motion, was to have them provide.
No, what I heard Commissioner Steig's motion to be was to recommend that staff look into it. But not, no, to know that staff will look into it, but that there will be an appeals process. I mean, did I maybe I misunderstood your motion.
I didn't think that that we had the power to require it, and we were, my motion endorsed the concept and asked the staff to look into it, subject to our endorsement. I thought that was about the maximum I could do under the law.
So I apologize if I wasn't clear. The city planning commission can make any recommendation that it wants. At this point, we have not had the opportunity to come up with a clearly defined process. And so if that was something that was causing the commission to be hesitant to move forward with some clearly defined process of its own, it could endorse the concept. My understanding is that it is something that has latched on at the council level in terms of, for the same reasons that have been discussed here, and that, considering it that we're in January right now and there are 2 more months before the council has to act, my guess is that there is some more definitive language that is going to be available by the end of March so that the council can act on something definitive. And so the recommendation of the city planning commission today would be to endorse the council doing that.
Okay, thank you.
So,
Thank you.
Madam Chair, I withdrew my motion, but since it had some facts in it, can I reinstate it with one change, which is to limit, as the slide up there says, one unit per owner. So no longer my suggested 3 or 2, just 1. And on the 1 per block face, we get to the same opposing forces. If we go to 1 per block, we're cutting out more and more and more people who have permits in good faith. But if we go to 1 per block face, we are, allowing 1 in every block. And it's again, those are competing interests. So I'm going to, at least in the motion, try to stick to 1 per block face with the endorsement of the concept of looking into it further under some kind of appeal procedure or other procedure that the staff comes up with. I just don't, Commissioner Lon, I don't feel comfortable like crafting a whole solution sitting here. I can barely get a
I
motion
understand.
that makes any sense.
You're a lawyer and I'm not.
So I thought endorsing it and leaving it to the staff was about the most we could do.
No, I understand. I just I needed that explanation. Thank you.
Okay, with that motion, do we have a second?
Can I ask safety and permits a quick question? Yeah, I know you can't, I know you don't have the data specifically at your fingertips, but when our staff came up with the 1 per block face, was there any sort of communication as to how many might be cut out if we did that? And where that concentration was in the city?
So I will defer that back to the CPC staff. They're the ones who looked at it rather than safety. and permits.
Okay,
We did. We pulled the data, so we looked at it. There's between 128, 140 block faces. We're gonna have multiple permits per block face. A lot of those cases, I think 80 of those cases are you have a partial unit and a small in one structure. And so in those cases, either one of those units would, if it's the only 2 on the block face, would be allowed to maintain their permit.
Good.
Hold on, I think I have the number for
Okay.
how many would be
okay.
affected.
I don't want to belabor, but I just, that is the only problem I have with Commissioner Steig's motion is that we've heard that if we go with 1 per block face, i.e. 4 in a block or a square, then we could potentially have an increase in some neighborhoods. And that's where we don't want to get into displacing people who are operating legally, but we also don't want to have certain neighbors overburdened as they are now, and also eliminating housing stock. So
Commissioner Stig, can you restate your motion again so you get a second?
Well, just one second right before that. I have one more question for the staff. Can you hear me? I somehow missed this in all the other discussions. In Article 20.2, we say in our general standards, short-term rentals shall not be operated outdoors in an accessory structure or recreational vehicle. does this satisfy the accessory use argument?
Let me take a look.
Because again, I don't want that little piece to somehow be taken advantage of.
Excuse me, if I recall, that's included in the use standards for the current residential short-term rentals.
Yeah,
I believe what we did is we took all of those and we relocated the use standards in Article 21.
Mhm.
So is that correct?
To Article 21.
To Article 21, yes. So that provision would now be proposed for Article 21 in support of the temporary short-term rentals. Is that correct, Paul?
Yes, and also there are some general standards that apply to both non-commercial and commercial that are still in Article 20.
In layman terms, then?
The
So
answer is yes. Vision would still be applicable
To accessory structures.
to accessory structures, yes.
You cannot just turn an
Yeah.
accessory structure into a
So
SDR.
I think what Paul was saying is that there are general standards for accessory structures that do not allow them to be dwelling units. And a dwelling unit is a prerequisite for a short-term rental. It has to be a dwelling unit. So
Dwelling unit meaning a unit for the kitchen?
yes.
Yes, okay. And so I know there's a thorny area, but with accessory structures and bed and breakfast. So can you just clarify that for us?
Can you explain the thorny? I mean, it's the
Bed and
same.
breakfast with, so all I'm saying is it the same standard? Is it the same?
So the standard doesn't just differentiate between bed and breakfast.
Okay.
Or regular dwellings
Unit?
or short-term rentals. If it's an accessory structure,
It is an accessory.
it cannot be an occupiable structure. So it can't be turned into a short-term rental. It can't be used for a bed and breakfast. It can't be used as a residence.
Okay.
Correct.
Unless there's some kind of grandfathering or that exists.
So
But
if
the current
I-
regulations do not allow for it.
Thank you. I mean, there were some clarifications from people who had written emails about that. So thank you for that.
So if I have a single family home and I have an accessory structure in my rear, that is not considered a dwelling, so that would not be considered a short-term rental.
Right.
Commissioner Stieg? Is there anything else regarding your motion, or is there a second?
I think Commissioner Stewart wanted to. So you would have to ask me that, right? My motion is to accept staff recommendation with these changes. Guest limit of 6 per unit. Bedroom limit of 3 per unit. Limit ownership to 1 per owner. Keep the requirement of 1 per block face. And endorse strongly the idea that a process would be developed pursuant to which individual exceptions or exemptions could be considered, perhaps along the lines of the review of the IZD process that Executive Director Rivers described, so as to evaluate and consider granting permits more than 1 per block face where circumstances warrant.
Second by Commissioner Stewart. I have a question for Ashley Safety and Permits. If this current motion moves forward, and there's a limit of 6 people that can stay in a residence, what happens if Safety and Permits finds out that there's 7 people or 8?
That would be a violation of the law for which we could, if we felt that we could prove it, proceed to an administrative hearing and present that evidence to an an administrative hearing officer to seek either fines, suspension of the license, or both.
And I just want to clarify that we keep the requirement that the owner and the operator be a natural person. But we keep everything else in the staff report.
Thank you, Commissioner Sieg. I am in support of this motion with the assumption that the endorsement or that the methodology for appeal will happen. It would be extremely unfortunate if that was not the case. Is there any further discussion? Or if not,
Just want to ask when you say a person, we mean an adult 18 years of age and older, or children are included?
It would depend on the exact text of the law passed by the city council.
I have a question. Does this include the changing to a temporary use? Temporary use? Does your motion include moving from the current way that we view it as a permanent
Yes.
right to temporary use? Okay.
And your comment just raised another loophole. We're discussing loopholes. Staff, would it not? Oh. So we don't want to have the possibility that somebody puts a property in their son's name and a property in their daughter's name and et cetera, et cetera. I mean, we want. Okay. So I'm going to add to my motion that it's a natural person 18 years or older. Can I do that?
Yes.
Yes, absolutely.
And
I thought her question was about guests and not owners.
And I think that stipulation is in the staff report, but I'm
Oh,
not
was it?
sure. I think it is. Oh, okay. Okay, but it does. Okay.
Commissioner Sieg has amended his motion to include the
Second.
person be 18 years or older.
That's-
Okay, if there is no further discussion regarding this matter, I'll call the question. Vote your machines.
Um,
8 yeas, 1 nay, motion passes. Our next docket item is going to be the zoning docket 9522, which is the IZD for banning all residential short-term applications. Is that correct? Is that for a period of 1 year?
Yeah, so the IZD is in place now because the council introduced it. And if the process continues moving forward, so if you all approved it and it went to council, the date that the ordinance is signed is the effective date, and then it's in effect for 1 year from that date. Is that wrong?
Thank you.
They can rescind it. So what they would probably do is once they establish a new permitting regime, they would rescind that IZD.
Would they have to do that legally, or we would just assume that they would do that?
They would have to go through a full process to do that, right? Is my understanding? To rescind the IZD once they have a new regulatory regime for STR residential, the IZD would be rescinded. Is it through council motion or?
I think it depends on, now that, the regulations and the IZD are moving at the same track. It conceivably could be that they get to the council at the same time.
Mhm.
And if that happens, then the council could rescind it at that time. But otherwise, I do believe there has to be a separate motion. And so in other words, the motion that they created under is still pending until the ordinance is finalized. So they could rescind it as part of that process.
Thank you. Is there a motion? Questions for staff?
I'll make a motion for zoning docket 09522 to move forward with Zach staff recommendation.
Motion by Commissioner Witry, seconded by Commissioner Steig to accept staff proposal. Is there any discussion? Sorry, can I ask, I need to ask another clarifying question. This zoning docket says that all STRs are banned. And then when March 31st comes, which is when the city is mandated to roll out new regulations, that they will then rescind this ban at that date or at a later date whenever they've gotten their things together.
So the purpose of the IZD was, I mean, the IZD was introduced months before the regulations were introduced. So the purpose of it was to freeze things in place in accordance with the litigation and the judge's orders in the litigation pending the adoption of new regulations. So the intention is for the IZD limitations to go away once the new regulations go in place. Most likely two scenarios. One is that there would be, both of them would get to the council at the same time. And in the same time that they would adopt the new regulations, they would rescind or withdraw the pending legislation on the IZD. The second scenario is if the IZD moves forward before and gets a final ordinance before the regulations, the new regulations can be considered or before they go into effect. When the council considers the zoning, the ordinance on the IZD, they would include language basically saying they are in effect until either a date or until the adoption of the new regulations.
Thank you.
I have one more question. Under general information, under general information, location, it says this is a citywide prohibition. It includes all zoning districts. Is that all?
Yeah,
zoning?
technically it is all zoning districts. It's a citywide, but it is where it's most impactful where residential, short-term rental, small, partial unit, and large are allowed based on the use permissions. So that's where the major effects will be, right? Because in those districts where short-term rental, small, partial unit, or large is permitted right now in the use table, people can't pull a new permit.
It basically prohibits the issuance of a new residential type short-term rental.
Mhm.
If there's no further discussion, we'll call the question. Seven yeas, 2 nays, motion passes. Our last item that we didn't cover was subdivision ratifications.
So there was in your packet, there was a list of subdivisions that had been administratively approved. And those are up for your consideration for ratification.
Looking for a motion?
So moved by Commissioner Stewart for subdivision ratifications.
Witry will second.
Thank you. If there's no discussion, we'll call the question.
It's switching. There we go.
Okay, let's vote on machines. Motion passes. That concludes our business for today. Looking for a motion to adjourn.
Before with the motion,
Yeah.
can I just reiterate
Sure.
that if you all did receive any communications about any of the matters that were before you, that went to you directly, you send them to me, so I can include them in the record.
And also, I just want to thank Ms. Becknell. It's very helpful that when we have questions about safety and permits or about departments that we're not super familiar with, for you to be here to be able to answer the questions so that we're just not making assumptions.
Thank you so
So
much.
thank you
Yes.
for taking the time on Tuesday and today.
And one more thank you to staff. Staff, I know y'all have been working really, really, really hard on this under a serious time crunch. And you're doing a great job with it.
Yeah, and I want to commend Laura for fielding all the hard questions.
Yes.
amazing.
Yes, thank you, Laura. Thank you, Paul. Thank you, all the staff, and of course, Ashley too. Appreciate it so much. And everybody who came and spoke on this matter. It's been a hard one.
Thank you to all the commissioners.
So Paul, are you gonna explain to everybody?
Motion to adjourn, please.
Move to adjourn.
Let's vote on machines.